chrisbebel here again. I'm a former SEC attorney and I'm a former federal prosecutor. Today, let's look at some more of the arguments that brokerage firms are likely to make in order to try and escape liability. First of all, they often argue, and it's perplexing that they routinely make this argument, because the regulatory decisions, the decisions from the SEC and the decisions from FINRA make it clear that this argument deserves no weight. But nonetheless, the brokerage firms argue over and over that they can't be held liable because the stockbroker who engaged in the underlying misconduct was an independent contractor as opposed to an employee. Well, it's fair to say that that argument is completely frivolous. It's spurious. There is no way that a brokerage firm is going to get any traction by making that type of claim. And logically, that makes sense. And let me flesh that out. You see, the state and federal securities laws set up very onerous, detailed, intense supervisory requirements. The brokerage firms must supervise brokers at a very basic, fundamental level. And they must diligently and vigorously supervise that stockbroker each and every day. And if the brokerage firms could simply cast an independent contractor label on some of the stockbrokers, they could, in effect, do an end run around the customer protection standards that are embedded in state and federal securities law. So that argument makes no sense, and the brokerage firms are unlikely to prevail on that front. Now, let's go to another argument that the brokerage firms routinely make. Well, they say that the broker, his conduct was so bad that he essentially engaged in criminal conduct. Once again, that argument is frivolous, it's spurious, it's not likely to get any traction. If you look at the range of cases that are pursued against stockbrokers, each and every day, week after week, month after month, year after year, it becomes clear that there are a number of highly egregious, outrageous fact patterns that are pursued, and that brokers engage in outrageous events while defrauding their customers. Now, that's not true for all brokers, but it is true for some brokers. And in a nutshell, it's fair to say that the brokerage firms can be held liable so long as the conduct was foreseeable and based on that vast range of actions, disciplinary actions, criminal actions, and so on, that are pursued against stockbrokers each and every day. It's going to be very hard to view the underlying conduct in an unforeseeable light. Now, once again, we're just painting with the broad brush. The specific details and the nuances of your particular case must be taken into account when fashioning an analysis that is geared towards the intricacies of your potential case. So if you have any questions, go to my website, chrisbebel.com, or give me a call at 903-843-5678.